Hello everyone, my name is Shadan Seraj and I am currently doing an internship at LEXIS and Company. So today's topic is res sub judice. Sub judice in Latin means under judgment. It denotes that a matter or case is being considered by a court or judge. When two or more cases are filed between the same parties on the same subject, the competent court has the power to stay the proceeding. However, the doctrine of res sub judice means stay of suit. This code provides rule for the civil court in respect of the doctrine of res sub judice. Section 10 of the Civil Procedure Code 1908 stay of suit deals with the concept of res sub judice. The objective behind inserting the section 10 of the stay of suit is to prevent parallel litigation in two different courts between the same parties on the same subject matter, to prevent wastage of the court's resources and time, to avoid two contradictory decisions on the same subject matter, to reduce the burden of the courts, to protect the rights of the other party, and to avoid unnecessary delay. Conditions necessary for the application of Section 10 are the same parties. For imposing stay under Section 10, the identity of the parties is enough. Parties in two suits need not to be the same. To apply Section 10, it is enough that the previously instituted suit is between parties under whom they or any of them claim litigating under the same title. Matter in the issue must be the same. For the application of Section 10, it is enough to establish that substance of the matter in controversy in two suits are the same. The identity of reliefs is not necessary for the applicability of this situation. Number 3, the suit must be pending. Section 10 gives the power to put stay on proceedings only if previously suit is pending. It is the duty and responsibility on the defendant to make the court aware about pending of former suit. But if it is pending in foreign court, then Section 10 is not applied. Title must be the same. To apply Section 10, the parties must be litigating under the same title under both suits. The court should be competent. Section 10 of the CPC is only applied when the previous suit is pending before the competent court. The essentials of Section 10 are that there should be two suits. The suits must be between the same parties or their successors. The matter in the issues in the later suit must be directly and substantially the same as in the previous suits. Both the suits should be pending before the court of law. The parties must be litigating under the same title in both the suits. If the above essentials are fulfilled, the court can stay the proceedings under Section 10 of the CPC. Now, the court may also use its inherent power to stay of suit. Although the provision of Section 10 is mandatory, but this provision has not taken away the court's inherent power under Section 151 so as to stay the proceedings on the facts and circumstances of a given case to secure the ends of justice where Section 10 is not applicable. Therefore, court may use its inherent power to secure the ends of justice when Section 10 is not applicable. Even to prevent abuse of the process of court may stay former suit by applying its inherent power. Now, does the Section 10 apply to the foreign courts? No. The Section 10 of Civil Procedure Code does not apply to the foreign courts. The pending of the suit before any foreign court does not bar Indian courts to initiate proceedings of the case on the same cause of action. Court cannot apply this section where point at issues are distinct and different, or even where there are some issues in common and others are different issues. This section is not applicable between the suits where although the parties are same, but the issues are not the same. In conclusion, res sub judice as a doctrine has the same main purpose of reducing the burden of courts from the abundant cases. In other ways, it also reduces the burden of parties to adduce oral or written evidence twice in different courts. It also avoids conflicting decisions and makes sure to minimize the waste of resources of courts. The court can exercise this power and put a stay on the subsequent suit. The people who try to misuse their right in order to get double benefit are looked after through this principle. Anyways, the Indian judiciary is overburdened with many cases, and if parties will start instituting cases twice, then one can't even imagine the situation of the courts in giving decision in all such cases. Thank you.